Hello, viewers. Welcome again to the series on AI and intellectual property. And Thanuki, thank you so much for being back again to talk about legal framework and AI innovation. So, continuing our discussion, Thanuki, I would like you to, just give the viewers a perspective. How does existing intellectual property law accommodate the unique challenges posed by AI generated creations?
Okay. So before we talk about how it accommodates the challenges, we need to talk about what the challenges are. So I'm just going to quickly go over that. So some of the challenges are, the first one would be when it comes to inventing or inventorship, the central issue revolves around defining who qualifies as an inventor. So that's the first concern. Usually the current standards say that this inventor must be a natural person, should be a human person. So, in that sense, AI lacks legal personhood. And then that raises a question whether you can recognize AI as an inventor ever. And if not, um, does that mean that the individual who developed that AI system or tool or algorithm, whatever it is, uh, whether that person uh, gets inventorship by default? Um, but this also kind of raises a bit of questions where um, when you take a certain invention, there has been equal parts contribution between an AI system and a human being. How do you recognize that? And I do not think that laws address that aspect as of yet. So that's your challenge and a few observations on how that is dealt with under the law or rather not dealt with. The next challenge is talking about ownership. So the question of ownership is also something that you can't talk about inventorship without talking about ownership. Those two are closely connected with each other. So if AI cannot be designated as an inventor, ascertaining ownership rights for an AI generated invention also becomes difficult. So then the question that arises there too is, should ownership rights belong to the developer, the user who developed who provided those input prompts, or the entity that owns that AI system, in the sense the company? How do you view that? So these questions are still unanswered in laws across the globe, and a lot of case law is what is kind of providing some sort of clarity on these areas. Then you have this aspect of another challenge is novelty. Novelty is a challenge. So when you are evaluating what is novelty, and there's also this aspect in intellectual property law where we talk about non-obviousness. So when you talk about both these criteria, it really hinges on this aspect of human knowledge and creativity. So then when an AI system is responsible for generating something completely new, then assessing those benchmarks and assessing what should count as novel, absolutely novel. That's how it is in our Sri Lankan Intellectual Property Act as well. When you talk about something that is absolutely novel and non-obvious, then coming to that benchmark and saying, okay, we've hit this, it becomes extremely challenging. Another challenge would be disclosure. So when it comes to patents, patent application processes, you need to provide a full disclosure of the invention to enable um, replication by a person who is skilled in that art. So when it comes to an AI generated invention, the fact that it's opaque, and also we know this term, the AI black box kind of concept, where it's sometimes, most of the time, it's unexplainable, then this disclosure requirement becomes extremely challenging. But these things are not catered for in laws across the globe. Um, so I think when we talk about what is to be done, I think under current legislation, AI cannot be recognized as an inventor. This is a problem. We need to see how um, how to accommodate that. It's something that needs to be discussed at length. And even when it comes to ownership, if you look at case law, they even in this case called Stephen Thaler, that particular case also, they were talking about upholding human authorship. and regarding AI as a tool rather than as a creator. So um, I think what is needed is having some sort of clarity about where we stand as a country, what our stance is pertaining to significant challenging concepts under with the use of AI, like inventorship, authorship, ownership, and those are the challenges, and those need to be addressed head on. Because right now, it's all, anyway, in Sri Lanka the conversation is very minimal on this, but even globally people are just relying on case law to arrive at this. But there needs to be some sort of guideline, there needs to be more discussion on this aspect for sure, to especially protect the rights of inventors and authors and balance that.
So you spoke about several things, right? You talk about an inventor, ownership, novelty, and it has to be non-obvious. And very especially, you also spoke about disclosure. So keeping all this in the background, you also briefly mentioned that this discussion in Sri Lanka is not mainstream. Probably it's happening in silos. But for the benefit of the viewers, could you tell whether the legal framework in Sri Lanka has does it sufficiently incentivize AI innovations while protecting intellectual property laws? Does it incentivize and does it protect the property rights, intellectual property rights?
Right. So the answer to both those questions would be no, it's inadequate. And okay, so the fact is that Sri Lanka is moving towards advancing technology. Obviously, we have the brains for it, we have the skills, the talent pool for it. It's not that we can't do it, but the problem is that there is this issue where we are lagging behind in terms of regulating um, this in order to protect and provide certainty instead of ambiguity in the event that there is some sort of dispute in the future regarding inventions or uh, authored works, anything like that. So I think the one of the key issues that we have is this, that the act recognizes human authors and human inventors. So there needs to be some sort of clarity provided regarding what our stance is in the event that a person has invented something or written something or created an artistic work using an AI tool. And how do we classify those inventions or creations um, as having met the requirements to basically meet as a work that requirements to be met to be a work that can be protected. um, because right now we are just talking about anything that is done manually, and things that are done in the sense of, let's say, computer programs. We're talking about computer programs and software, but we haven't explicitly recognized artificial intelligence. And why I think that this needs to be addressed head on and explicitly is because artificial intelligence is not like a simple computer program. It is evolving, and the potential it has to evolve into something completely different in the next couple of weeks to months is extremely high. So the law needs to be able to cater to this change. So I think that something that we need to look at is re-look at the way we see fair use, re-look at the way we would define an author, an inventor, re-look at what it means to have ownership over something, re-look at what it means to have joint ownership with a AI system, or authorship with an AI system that has assisted you to do something. And basically maybe incorporate this idea of sufficient acknowledgement into the fair use framework when it's an AI generated work, where a person acknowledging that helps to protect uh, the respective rights. And also, the fact that an AI system can be geographically distributed, and also this concept of death in our I mean since we're talking about Sri Lanka, this aspect of death or the end of protection with the death of the person, um, that is factored in to this in our legislation. How do we deal with this aspect of death of a creator where it is generated by AI? Because AI would not die. Then does this mean that we maybe require the creation or the invention basically to be public domain information so that it can be used? That's something that we need to think about. And basically also, I would think defining what constitutes a derivative work, which becomes more and more complex when it comes to the involvement of artificial intelligence, unlike what we are used to using now, is also necessary. So I think the golden thread that runs through this particular response of mine is that we require more clarity and some guideline on to understand what our stance should be when it comes to this conversation of intellectual property. And that needs to be accommodated by way of amendments to the Intellectual Property Act as soon as possible.
So what I'm hearing from you is this particular area where, very especially when we are talking about legal framework with respect to the intellectual property and fair use frameworks, requires a lot of discussion. But the challenge what we have is the world is moving fast. The technology is being evolving at a rapid space. That can our discussions also be accelerated? And I think that's a question I would leave it to the audience and our viewers to join hands in having this conversation in whichever way they can, so that we could accelerate this conversation and, if need be, look at amending certain laws. So that requires a lot of work. It's not going to happen overnight, but it requires a lot of in-depth discussion. Thanuki, thank you so much for those thoughts. So today we have understood the introduction to AI and intellectual property. We have briefly discussed the legal framework and AI innovation in the context of Sri Lanka as well. So I request our viewers to wait for our next edition, which will be on ownership and authorship in AI. Thank you so much, and thank you, Thanuki.
Thanks, Sujit.